All right, come on back. Come on back, everyone. Sorry about that. It's a Friday. Come on back, everyone. Hey there. Hopefully the technical difficulties have resolved themselves. I'm going to give this maybe 30 seconds for everyone to come back in and repopulate. Sorry about that. I apologize. I don't know what happened there. We're now in landscape mode instead of portrait. Maybe that makes a difference. We'll see if that helps. Sorry about that. Hey, welcome back, everyone. Wouldn't be Friday in a Facebook live chat without some technical difficulties. Okay, someone said I left off by saying laying off someone who I believe was immunocompromised. Okay, I'll get back to that second point in a second. We're going to let other people get back into the room. Hey. Rule of life, always trust a lawyer in a ramen shirt. That is definitely true. Someone asked who my broadband provider is. I'm not going to throw Verizon Fios under the bus. I mean, Comcast. No, Fios has been great. No complaints about Fios. All right. Hopefully we get some people back. Well, we lost a bunch, but that's okay. Okay, I'm gonna give it 15, 20 more seconds. I'll have to riff for a little while. Yes, Molly, technology is great when it works. When it doesn't work, not so much. This is true. All right. I'm not gonna touch the screen. I'm just gonna let it scroll. If I miss comments, here we go. Okay, let's continue on. So I was talking about the criticisms that Senator Murray and Congresswoman DeLauro had with the Q&A, not so much with the final regulations, although some of their criticism would apply there as well. And where I left off with is they both said that employers should not be able to reduce hours, furlough, or layoff to avoid providing paid leave, which is true in a sense, right? So if you know that someone is immunocompromised and you target them for layoff because you don't want to have to pay that person paid sick leave, that would be discriminatory. If you terminate someone who has already taken paid sick leave because you're upset about having to have paid it, that would be retaliatory. So I think that's where Ms. Murray and Ms. DeLauro were going with that. But I think it's very clear that if you don't have any sort of animus or a motivation to discriminate against people who are potentially immunocompromised or who would likely use the paid sick leave, but rather you're just doing it across the board to save money, right? Because you don't want to have to end up paying out the paid sick leave. Maybe you just don't have the liquidity to do that. Then you can do the layoffs, you can do the furloughs, you can reduce hours. The Secretary of Labor has said that, and I think that's accurate. The third criticism that was in the April 1st letter to Eugene Scalia was that employees should be allowed to take intermittent leave without employer permission. So we talked about this in a few of our chats, and I've talked about this on the blog as well, that originally when the Families First Coronavirus Response Act was presented in the House, there was language in there that precluded employees from taking expanded FMLA intermittently. Okay, and in later versions of the bill, that language was removed. So some of us were looking at the bill and thinking, well, if it's removed, maybe that means that employees can take intermittent leave under the expanded FMLA just like they could under regular, classic FMLA. But the Secretary and the Secretary of Labor in his Q&A said, yeah, I mean, intermittent leave is available. However, here's the catch, the employer has to allow it. So if the employer says, no, sorry, we're not going to allow intermittent leave for expanded FMLA and for folks who want to telework and get the paid sick leave, it's not going to happen. And that's what made its way into the final rule. And what Ms. Murray and Ms. DeLauro were saying are no, you've taken that too far, Secretary of Labor. If an employee wants to take leave intermittently, they should be allowed to do so, even without employer permission. So is that going to be a battleground for the courts if, let's say, an employer denies someone's ability to take intermittent leave? Is that something that's going to get litigated? Possibly. But if you decide not to allow intermittent leave, just know that the Secretary of Labor and the regulations are on your side. Okay? The fourth criticism is the definition of healthcare provider, to exempt them from coverage under the Families First Coronavirus Response Act. So we all know from classic FMLA, if you have 50 or more employees, right, when someone certifies that they need leave for their own serious health condition, they go to a healthcare provider. And that healthcare provider, there's a specific definition of what that is in the Family Medical Leave Act. So at first, we kind of assumed that that definition would carry over into the Families First Coronavirus Response Act when the act talked about contemplated exemptions from having to provide leave for those healthcare providers. Maybe it would be a narrow definition, but actually it's a quite broad definition. It essentially includes anyone that works for a hospital or a nursing home or really any business that provides healthcare in any sort of way. Anyone who works for that business can be exempted from being able to receive the paid sick leave and the expanded FMLA. If you contract with one of these companies, you may be able to exempt certain employees from PSL and EFMLA coverage. And Senator Murray and Congresswoman DeLauro took issue with that and said, look, the definition of healthcare provider here is way too broad, and it should just track the FMLA. Their final criticism was with the shelter in place, right? And just keep in mind, again, the timing. When they wrote to the Secretary of Labor, it was before the final, the temporary rule, the final regulation, so to speak, had come out. And before the final regulation had come out, it was really unclear to a lot of us whether one of these shelter-in-place, safer at home, stay at home, whatever the 30-some-odd states have issued, whether that would trigger possible paid sick leave under the first prong. That is, that a local, state, or federal government issues a quarantine or isolation order due to COVID-19. So they wanted some clarification on that. And the answer is yes. It does trigger potentially someone being able to get paid sick leave under the act. However, if someone is able to telework nonetheless, then they don't get the paid sick leave. Again, as I talked about in part one of this now two-part Facebook chat, and I'll post both of them. I don't know how I'm going to be able to marry them together, but I'll try my best. As I talked about in part one, that if the shelter in place is the but-for reason that you can no longer work, that is to say there's work available, and just because you have to shelter at home, you can't get to work, then yeah, you'll be able to get the paid sick leave. But if the shelter-in-place order is in effect, but also you work for a non-essential business and you've been furloughed, or there's no hours for you, or the doors are closed to the public, then you're not going to be able to collect paid sick leave. Those are the 5 criticisms that Senator Murray and Congresswoman DeLauro have. So those are the issues that I see outstanding, at least for now, with the Department of Labor regulations. Again, I would follow the regulations for now. I think you're in pretty good hands with the Secretary of Labor at this point, and you have a good faith argument if you have to God forbid if you were sued for violating one of these rules, you just say to the court, look, here are the regulations and we followed them. Then it's up to the court to decide if the Department of Labor and if you were right, and hopefully the court would side with you. So I want to pivot a little bit and talk about what's next. What is on the horizon? We talked a little bit about this last time. And so at some point, this is going to subside. Coronavirus issues are going to be over. And at some point, we're going to have to be thinking about return to work. But before we get there, we're kind of in phase 2 or phase 3 of this coronavirus issue. That is to say, phase 1 was me getting calls from employers saying, hey, Eric, we just had an employee tell us that they've come in close contact with someone who's come in close contact with someone who's showing COVID-19 symptoms. What do we do? All right. So the first part of this was lawyers becoming doctors to advise clients, should you close down the business? Who should you send home? Should you send everyone home? Should you telework? All that stuff. That's in the past now because most everyone is teleworking. We still get some of these questions, of course, from essential businesses, but mostly those questions are behind us, and there's better CDC guidance than there was before, and we have a better sense of what to do. Phase 2 was preparing for the Families First Coronavirus Response Act, and now phase 3 is, okay, it's in place. What do we do about it? So here's what I've been recommending to clients and to non-clients when I'm not giving legal advice is make sure, if you don't have one already, that you have a Families First Coronavirus Response Act policy that you give to employees. Of course, make sure above all that you're hanging the Department of Labor notice in the workplace. If you haven't done that already, it's supposed to be up, put it up. And if employees aren't coming into work because, your doors are closed, email it or mail it, get them copies of it so they know what their rights are, post it on the intranet, whatever you can do that's reasonable so employees know what their rights are under the FFCRA, okay? That's important. But then make sure that you have a policy. So make sure employees understand beyond what's in the notice how to apply for paid sick leave, how to get the expanded FMLA. So you have a policy, and also make sure that you have a leave request form. So that way, that's going to be your documentation. So when someone's going to make a verbal request initially, or maybe if it's easy enough for them, they'll pick up the form off the intranet or however you can get them copies of the forms, and they'll submit the form to you. And that form will be your documentation that if you have to provide it to the IRS in order to get your tax credits, it's there, and you're going to keep that paperwork whether you approve the leave request or deny the leave request. You're going to keep it for 4 years, okay? 4 years. So that's something that if you haven't done so already, I've been doing that for clients. I've developed forms and policies. You should be doing for yourself. Talk to your employment lawyer. I'm a member. I don't really want to shill for SHRM, but I will say they have a policy on their website. I've looked at it. It's okay. But at least have a policy. Having a policy and some supporting paperwork, leave request forms is better than having nothing. So beyond the FFCRA, thinking about how you're managing your remote workforce. I mean, for me, I've been remote working for the last 2 years. I work for the largest distributed law firm in the world. So this is nothing new to me, although my kids are at home. It's a little bit different. But for most of you, this is a whole new world where not just a few people are teleworking, but so many people are teleworking. So good communication, really, better communication than we're used to is so important. Making sure that you are communicating, whether in email or I'm sorry, millennials, you got to pick up the phone. Picking up the phone, calling people, letting them know, kind of keeping them updated, letting them know what the expectations are, work-related, letting them know timelines, breaking events, things like that. good communication is paramount. Also, as we've seen in the news recently, I don't know if you saw the story, I forget who the employer was, and I don't want to out them, but if you are going to do layoffs, right, like doing it on a live Zoom chat with 40 people who you're laying off in the same room, that's bad form. Don't do that. Don't do that. I understand that these are completely unprecedented times, but if you have to lay people off, and I realize you're busy and you have a lot of things to do, please pick up the phone and call them if you can. And if you can't, don't bring people in a group and do it that way. Zoom is okay, but just do it one-on-one if you can. Have your managers do that. So good communication. Talked about updating policies and procedures. So it's not just your FFCRA policies and procedures, but if you need a more robust telework policy and procedure, now's the time to start revising that. If your handbook needs to be adapted, thinking about your handbook, it may need to be adapted to take into account that you have more teleworkers. Think about revising your handbook. I know that's always like at the bottom of your list, but you may need to start to move that closer to the top. Retraining managers. So your managers are not used. Most of your managers probably aren't used to teleworking. They're probably in the workplace, looking people in the eye and managing face to face. They may need some guidance. They may need some training. They probably needed some training and guidance before all of this started. God knows I've seen a bunch of those performance reviews where people mentioned the letters FMLA. I wish I could take those managers out back and do something bad to them, because those are the lawsuits that I have to defend. But really training your managers, and I realize folks on this video, you're learning too. It's someone told me the metaphor or analogy. I like this, that we're flying a plane that we're building at the same time. So I get it. We're really learning on the job here, but making sure that your managers understand what their obligations are, what they should be doing to manage their workforce during these times. That's really important. Very clear set of expectations. And I'm rambling, but you understand my gist. Documentation. So fortunately, if we're communicating more via email, Slack, text, and less face-to-face, we actually have built-in documentation, which is great, like that we wouldn't have had before. It almost forces your managers to document issues, but that's what they should be doing more so than ever. Is documenting not just bad things, but good things, because ultimately you're going to have to do your performance reviews, and it's other, God forbid we have lawsuits that arise out of this. I'll talk about that in a bit. We are going to have a lot of lawsuits that arise out of COVID-19. So one of the most important things you can do, one of the best defenses that employers have when these lawsuits arise, is that we have good documentation from employers. That, here are the performance issues. Here is the progressive discipline that we issued. Continue to do that, even though we're working remotely. And then finally, I mentioned this during the last Facebook Live, that's time tracking. The Department of Labor, in its temporary rule, in its regulations, said that if employees work remotely, but employers, and I'm paraphrasing, basically don't know that they're working, right? Employers aren't responsible for paying that time. They're only responsible for paying for the non-exempt employee time. This is for non-exempt employees. For their time that they know about or should have known about, okay? So time tracking is really important. Making sure that your employees are tracking their time, whatever your system is, that they're not working off the clock, so to speak, that they're not working overtime without your permission, if that's what you insist upon. I mean, those rules should continue to apply, and remind your employees and your managers that these rules continue to apply, because I think one of the biggest lawsuits or biggest category of lawsuits that we're going to see after this is all said and done, and I don't know that they're going to be really high ticket items, but in volume they're going to be big, are Fair Labor Standards Act lawsuits. Mostly arising from the failure to pay paid sick leave, but also from the failure to pay overtime. I think we're going to see those as well. And those are the ones that are going to be a little bit more involved and a little bit more expensive to litigate. Thinking ahead even more than that, and I don't want to get too far ahead of our skis, is return to work. And it's not like we're going to snap our fingers. All of this COVID-19 stuff's going to be gone. All the businesses are going to reopen, and everyone's just going to kind of file back, single file, into the workplace, go back to their cubicles, workstations, and offices, and everything's going to be, just the way it was. No, I mean, we're still going to have people who are sick and recovering, who are immunocompromised, who need extra time. I want you to be thinking about the Americans with Disabilities Act and how to accommodate them. I want you to be thinking about, and you should be continuing to think about this now, classic FMLA. So if someone has coronavirus, that is probably a serious health condition, okay? So if you have 50 or more employees and that employee is eligible for FMLA, you should be providing the paperwork. You should be giving them Family Medical Act leave. So FMLA leave, excuse me. So thinking about FMLA and return to work. Also thinking about pregnancy accommodations. If someone who is pregnant needs an accommodation, that person receives the same accommodation that's as someone else who shares the same inability to perform work. So you basically find people who are not pregnant, who are similarly situated to that pregnant person, and you give that pregnant person the same accommodation that you would give someone else who isn't pregnant, who has the same inability to work. So just be thinking about that as part of return to work and accommodations. Age, you don't have to provide any accommodations. There's no duty to provide accommodations under the Age Discrimination in Employment Act. What I'll counsel you on, again, this is not legal advice, but what I will give you as not your lawyer, but just basic tips, is that avoid the stereotypes, okay? Right? Don't tell the older workforce that they can't come back to work because you're concerned that they are immunocompromised. I mean, unless you're getting specific guidance from the CDC or from the EEOC that older employees should not be coming back to work, right? You should be if you open your doors, everyone can come back, all right? That's important. So don't single any folks out. Let's talk a little bit about the next phase, and that's the lawsuits. And I'm curious to hear from folks here. Feel free to comment while we're streaming here, and it doesn't just have to be from lawyers. And again, when I see your comments, I assume that you're commenting for a friend, and you're not talking about your own workplace or any potential legal issues that you may be facing. But I want to give you my sense of what I think the top lawsuits are going to be, and then if you agree with me, great, throw a thumbs up. If you think there are some other ones, just please post them, make some comments, because I think folks here would like to hear from all of us. Although I'm the only one that has the microphone today, which is fine. So the biggest category of lawsuits, or at least the most volume that I think we're going to see, is definitely Fair Labor Standards Act, because the failure to pay paid sick leave is an automatic minimum wage violation under the Fair Labor Standards Act. So that lends itself to a nice collective action. Now we're talking about failure to pay paid sick leave over a period of 2 weeks, and it's capped at $511 per day. If you're a full-time, if you're taking leave for one of the first 3 reasons, and $200 a day if you're taking leave for one of the second 3 reasons. And no, I'm sorry, folks, I still have no idea what it means to take leave for, what does it say here? if you're experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. I have no idea what that means. I don't think anyone does. The Secretary of Labor totally punted on that in the regulations. But we're not talking about big ticket items. And even in the aggregate, if you put together 10, 20, 30, 40 employees, it's not huge. But there's going to be a lot of volume. Because I think smaller employers, the ones that are, fewer than 50, are going to struggle with this. And, you folks who are attending this live chat, you folks who are reading all the blog posts, not just my blog posts, but, you're just staying abreast. You know that the Families First Coronavirus Response Act even exists. I'm guessing there are some employers that don't even know that. There's going to be they're going to be employees that take the leave that aren't getting paid, that literally aren't getting paid. They're paid sick leave. And those are going to be the lowest hanging fruit and the most common actions that I see in the federal court system. Now, the issue here is, on the other side, is if companies can't afford to pay the paid sick leave and they go out of business, then is the juice really worth the squeeze when you bring the lawsuit? I don't know the answer to that question. If the company has insurance, maybe it is, although most EPL insurance policies don't cover the wages. Some do, most don't. But I think that's going to be the biggest claim. The other claims, in no particular order, that I think we're going to see in the top 5 are the Americans with Disabilities Act claims, arising from just a failure to accommodate. I think those are going to be the big ones. Someone says you were going to address the fear to return to work. I'm going to get to that in 2 minutes. I think we're going to see FMLA claims for, again, just folks that maybe forget that someone who has the coronavirus, who works for a company with 50 or more employees, that worked at a location with 50 or more employees within 75 miles, that's been with the company for a year, that's worked 1,250 hours, just they need the leave, right? Don't forget about that folks are still entitled to FMLA leave. And if those folks are getting laid off because maybe the business turns south or turns further south during this coronavirus epidemic, the timing may be such that someone feels as if they're being retaliated against for taking the leave. So I think FMLA claims are going to be particularly big. Now, what about the folks that are scared to come to work? Okay, so here in the Garden State of New Jersey, we have a very robust, if not the most robust, whistleblower law in the country. Show of hands or show of thumbs up or hearts or whatever it is you guys like to do. How many folks here have a business in the state of New Jersey? No one? Oh, great. No, well, it's okay. It's fine. But who here operates in a state where they have a whistleblower law? Oh, there's one heart. Who here operates in a state that has a whistleblower law, or at least are they aware of a whistleblower law? Yeah. So I think if folks are scared to come to work here in the state of New Jersey, you could have a whistleblower claim if you reasonably believe that what your employer is doing violates the law or is contrary to public health or public safety. Okay? So if you take that stand, if you say to your employer, look, I'm scared to come to work because you're not providing the right amount of PPE, you're not taking reasonable precautions to protect us from coronavirus, because whatever, if it's couched in terms of public health, or I suppose if an employee in the Garden State were to say, you can't make me come to work, I'm subject to a stay-at-home order. You're making me you're violating the law. Now, I don't know if that's a reasonable position to take, okay? But I don't know that a judge is going to decide that at the outset. That may be for a jury to decide. So in New Jersey, all it takes is a reasonable, good faith belief that what you're being asked to do by your employer violates the law or some rule or regulation or is against public safety or public health. So folks that are afraid to come to work, if you have a statute, a state law statute, that's redundant. If you have a state law or a local law that is patterned after that, then you may be facing whistleblower claims if you fire those folks who don't come to work. Okay. Now, here's an alternative that you should think about and talk to your employment lawyer about this. Don't take legal advice because I'm not providing it from a guy wearing a ramen shirt, okay? Instead of firing someone or disciplining someone for not coming to work because they are afraid or scared, just tell them, look, you can stay at home. Unfortunately, we're not going to have any hours for you, but we'll keep your job. We'll keep it open for you. We hope, we're doing everything we can, but we're gonna look to fill your hours with someone else. We're not gonna fire you. We're not gonna discipline you, but we just don't come in. I think that's okay. Now, the other related issue, and we're seeing news stories about this, right? Hospitals that are supposedly telling nurses and doctors that if you post about how our PPE isn't up to standard or how there are safety issues at the hospital, we're going to fire you, right? What's the problem with that? Let's assume you operate in a state with no whistleblower law. What happens if a bunch of employees get together and talk about the terms and conditions of work, and then they're disciplined for it? What does that violate? That could violate the National Labor Relations Act. So I think what you're going to see out of this, if folks are being disciplined because they're talking about working conditions or safety conditions about work, you're going to see a lot of unfair labor practice charges filed with the National Labor Relations Board. Now, not everyone who's watching today works for a business that's covered under the National Labor Relations Act, but I'll bet most of you do. And this holds true even if you're not in a unionized workplace. I've said this many times on the blog. The National Labor Relations Act covers protected concerted activity, usually 2 or more employees talking about working conditions. It protects them from doing that, not just in unionized workplaces, in most of the private sector. So just think about that, consider that before you take disciplinary action or before you threaten to take disciplinary action and chill this speech by your employees. I think the better approach, obviously if you can, is to get better safety equipment, to make your workplace as safe as possible. Hold on, I see a question that I really want to answer here. Let's see. Someone's asking, still so confused on whether or not we should be paying under PSL if the business is essential and open and employee is just afraid to come in. I think in that situation, no, you're not paying PSL because the employee, there is work available for that person, right? And there aren't the circumstances, the extenuating circumstances through which they're unable to do the work are their own subjective fears that they're going to get coronavirus if they come to work. So if the employee physically can't come to work because of the stay-at-home order and there's work available, that's one thing, okay? But if they just have subjective fears that they can't come to work, it's an essential business, then I don't think they're eligible for the PSL in that situation. They may be able to use their paid sick leave, their own PTO that the employer provides, but I don't think they're eligible for the PSL. The last of the big category of lawsuits that I think we're going to see are what I'll call the EEO lawsuits. Okay, the EEOC has been talking about national origin claims, and I'm not gonna make this a political conversation. Just suffice it to say that the EEOC has been highlighting national origin claims as particular low-hanging fruit for the agency to enforce Title VII against employers that have bias against Asian Americans, okay, amidst this coronavirus outbreak, okay? I think the EEO claims could also come in the form of ADEA claims. Talked a little bit about that before. If you're stereotyping older workers and not having them work because they're older, you're going to get an ADEA claim. It's no different than the pregnancy claims that we see and have always seen leading up to this coronavirus outbreak, right? When you as an employer think that I'm going to decide for my pregnant employee not to have them work because the work that they're performing is taxing, it's stressful, it could harm mom or the unborn child, right? That violates the Pregnancy Discrimination Act. So if employers continue stereotyping that way, I think that's going to be a problem. And then ultimately, what's the biggest EEO claim we see all the time, every year? What's number one? Without a doubt, it's retaliation. So anytime an employee raises a complaint of discrimination that has anything to do with coronavirus, that has anything to do with a protected class, if you then discipline that employee, boom, retaliation claim. So I think that's going to continue to be hot. Those are the 5 categories: FLSA / wage payment and collection law on the state level, age discrimination claim, Americans with Disabilities Act claims is 2, third claim is FMLA, fourth claim whistleblower / National Labor Relations Act, and fifth is your kind of EEO type claim. I think those are going to be the big ones. I have some time left for questions. I think I'm going to shut this down around 1 o'clock. If we run a little over, no big deal. I got some. I think I scared the heck out of people when I asked for one single question yesterday. I didn't get many, but when I kind of opened it up to more questions today, I got more. So let me go through a couple of them. And I'm not going to do all of them, but let's see if I can do some. So here's someone from Iowa who asks, she says, I'm a big fan of your blog, thank you. And a friend of mine asked if employers considering offering hazard or incentive pay to workers unable to telework should be concerned of increased liability because they might be seen to admit that working now is more hazardous than under normal non-pandemic times. I don't know about that. I don't think there's any obligation. Let's flip the question a little bit. I don't think there's any obligation to provide hazard pay. Hazard pay is really narrowly defined, at least under federal law. I can't tell you state law. I'm not licensed to practice in all 50 states. I'm not going to get into hazard pay under state law. But under federal law, where you see it come up is in the context of the Fair Labor Standards Act. And it's defined really narrowly. It usually involves situations in which there's physical hardship or extreme physical discomfort and distress. And I don't think we're there yet. If we're there, then companies like Instacart and Amazon and Whole Foods are in a heap of trouble, or potentially in a heap of trouble. I don't want to get them in trouble. I don't want my packages to be delayed. But potentially they're in a heap of trouble because we've seen the delivery folks threatening strikes because they're not receiving hazard pay. So I don't think hazard pay is a responsibility here to pay extra because we are in coronavirus times. But I think if you do provide hazard pay, fine. I mean, you do what you have to do. I don't think you're making any concessions by providing the hazard pay. In fact, I just think you're doing your employees a solid by giving them the extra pay. And you may need to. Like if you operate, a supermarket or a gas station, or you are a box store I'm just scrolling down to make sure I see all the comments, that you may need to provide additional pay in order to incent employees not to quit or to seek other avenues for remuneration, like unemployment compensation. Because I don't know if you guys have run the numbers. I've started to run the numbers, but someone who makes, $15, $10, $20 an hour minimum wage is going to make a lot more through unemployment than they're going to make by hour coming in to work in your office. It's not even close. It's not even close. I mean, in the state of New Jersey, you max out at $721 a week for unemployment if you earn enough, and then throw $600 a week from the feds on top of that. You're annualizing it like, way more than $50,000 a year. Why wouldn't you do that? I mean, you can get that. You can get unemployment and that federal unemployment for 4 months, $1,300 a week. So, someone says in New York State combined, it's like $1,105 or so. Yeah, multiply that by 52 weeks. That's a pretty good deal. Obviously, this only goes for 4 months with the Fed. So, you got to do what you got to do. If you have an essential business and you need to retain your workforce, you may need to throw some money, some extra money out there. Oh, mahalo from Hawaii. I appreciate your honesty and straight talk regarding HR. You know what I appreciate? I appreciate training workforces in Hawaii when the coronavirus pandemic calms down. So, I don't want to pitch. I probably shouldn't be doing that. No advertising here. I just say hypothetically, think of someone from the mainland, maybe someone from the East to do your next training session. Not over Zoom. It's got to be in person, okay? Let's see. Here's another question. For those employees who have accrued vacation and sick leave available, are they required to use those hours before the paid sick leave and the EFMLA occurs? No, they're not. You don't have to. Employees have the option to use other forms of leave first, but you cannot require them to do so. Here's the thing, though. If you check out the regulations, this was a little unclear to me, but now it's more clear. After 2 weeks of the unpaid expanded Family Medical Act leave, so reason number 5 for paid sick leave, when you're home, no child care available, kids' school is closed, you're the caretaker. After 2 weeks, either the employee or the employer can elect to run paid time off concurrently with the 2/3 pay under the expanded family medical leave for the remaining 10 weeks. So that's where it arises. Here's a question I got from an attorney from Pennsylvania. Hello, from across the river. I grew up not too far from you in Pennsylvania. Here's the question. Seems the regs seem to disallow asking for a doctor's note and just permit asking for a name. Do you believe employers have the right to make inquiries to ensure that the doctor has actually required quarantine or the employee sought diagnosis due to COVID-19 reasons? Yeah, probably. I mean, under the Americans with Disabilities Act, probably you could do that and get away with that. But do you really want to do that at this point? I mean, here's the thing. Let's keep this all in perspective. For an employer that has to provide the paid sick leave and the expanded FMLA, for all employers with one employee all the way up to 499, right? You're going to get the money back in tax credits. And really, all the IRS and the DOL are asking for is just some basic documentation that doesn't include the note from a doctor. And you're probably not going to be able to get a doctor's note. Doctors are completely inundated right now. So asking for a note is that might be asking for a lot from an employee. I mean, imagine like how hard it's going to be to get FMLA certified at this point, just for regular FMLA. So asking for a doctor's note on top of that to substantiate paid sick leave, the government said you don't need it, so why bother? I don't think that's necessary. Here's a question from Texas. If I work for an employer that currently has more than 500 employees that are still considered essential and the business turns, and we have to lay off a majority of our staff, this person should, by the way, hypothetically, should be looking into CARES Act PPP loans. Show of hands, hearts, thumbs up, whatever emoji you want to use. Who's looking into those PPP loans? That's like, yeah, I don't want to say that's found money, because that's too much of an oversimplification for it. But if you got a small business, that is something that, if you haven't talked to your accountant, lawyer, looked into yet, it's really, I suggest that you look into it. I don't want to give, again, no legal advice, but you should be looking into those CARES Act PPP loans. So again, getting back to this question, we have to lay off a majority of our workforce, and if that brings you below the 500 employee count, do you have an obligation to provide the FFCRA leave? Yes, you do. Now, not to the folks you have furloughed, not to the folks you have laid off, but to the remaining workforce. What you do, when someone requests leave, you take a little snapshot. The snapshot is on the day that leave is to begin, okay? And you check, do you have 500 employees? And there's this whole test for adding up 500 employees. You look at payroll, there's joint employer, this and that, and if you have affiliated companies, blah, blah, blah. But basically, you look at your payroll when leave is supposed to begin. And if you have 499 or fewer employees, then that person gets leave. Now, if a week later, if you start off with 499 and a week later you hire one more employee, right? The person who got leave once you had 499, they're grandfathered in. But when the next person asks for leave and you're at 500, that person doesn't get leave. So it's always, it's like a running tally of whenever the leave begins, that's the snapshot you take to determine whether someone gets the gets the paid sick leave, or frankly, the expanded family medical leave. Let's see. I have some other questions here, and frankly, I didn't have oh my God, oh my Lord, here's someone that asked literally 10 questions. This is overwhelming, and I should have gone through and previewed some of these. I'm just trying to eyeball some. Do you have any extra insight into what an individual under number 4 of the paid sick leave under the FFCRA is? And I do have some insight. Bear with me 1 second. Let me pull up my regulations. I didn't memorize it, unfortunately. Let's see if I can find it really quickly. An individual. It is, in a nutshell, it is someone in your household, like a loved one. It is a roommate, or someone for whom, and again, I'm not quoting it. I should be quoting it. For someone for whom it is reasonable to assume that you'd be the first person providing the leave. So not providing the leave, for caring for the person who is sick. Reason number 4, just so people, and I should have explained this. Reason number 4 for taking paid sick leave: you are caring for an individual who is subject to an order, as described in paragraph 1, which is the quarantine order by the Fed, state, or local, or someone's been advised by a healthcare provider to self-quarantine. So if you are tasked with taking care of that person, that individual, who is the individual? And the individual is a loved one, a roommate, or someone where you have that relationship, that tight bond. Probably not the person who lives down the block, but probably not your friend's friend, but could it be your grandparent who you have to go to their house to take care of them? For sure. Could it be an older uncle or something like that? For sure. So that's what individual means. Let's see. Do folks have questions in this chat? I can take a few from there as I try to skim through. I'm looking for some of the easier questions here. I probably should have previewed these before we got started, and I don't want to take up too much of your time. Ask some. I'm going to scroll through and let's see if I can find any questions. Let's see. Does number 1 in the provisions for PSL include an ER's self-screening policy? If so, should ER... an employer. Does number 1 in the provisions for PSL, so we're talking about the quarantine or isolation order from the state. I have to expand this. Hopefully I don't cut everyone off. No, I lost it. Sorry, folks. Let me see if I can find this one again. Does number 1 in the provisions for paid sick leave include an employer's self-screening policy. I don't know. I don't think so. It's a federal, state, or local mandate. Question. So if an employee's child has extreme asthma, is that covered? That's a classic FMLA situation, right? Now, let me also add on to that. So the question was, if an employee's child has extreme asthma and the employee has to take care of that child, are you going to get, it doesn't say, are you going to get paid sick leave? And I'll talk about that in a second. You're probably going to get Family Medical Leave Act leave, okay? So that's one, if you work for an employer with 50 or more employees. But the other thing is, if the child has been advised to quarantine because of concerns related to COVID-19, okay, that now brings the parent into coverage, the employee into coverage as well. So that is number 4, where you're caring for an individual who has been advised by a healthcare provider to self-quarantine. All right. So that's, I think, the answer to that question. Next question, Jim asks, is this daily? Meaning these chats? Heck no. I got to bill some hours. We're going to do these, maybe once a week, twice a week if you're lucky. Do you think an employer can require employees to wear face masks? Answer is yes. No question about it. You can, under the ADA, yes, you can require employees to wear face masks. If you are a restaurant, the problem is these questions are too long. I can't see all of them. So keep your questions really short so I don't have to expand them. I have to skip this one from Tracy. I'm sorry. Sherry asks, please expound on what it means to run accrued leave concurrently with EFMLA 10 weeks. Oh, you really want me to do that? Yeah, I mean, I think basically, I think there are two options. One is that the employer and employee can agree to supplement the leave. So if it's like you get 2/3 pay up to $200 a day. So you could fill in the gap with a 1/3. That would be a supplement. But to run concurrently, what the rule says is that either the employer or the employee can elect to run PTO concurrently with the EFMLA. So if I have a bank of, 10 accrued but unused paid time off days that I haven't used, and I get into that final 10 weeks of EFMLA, then my employer can insist, or I can elect to get paid for those 10 days alongside the 2/3 pay that I get up to $200 a day for EFMLA. Here's the catch with that. The catch with that is everything above the 2/3 EFMLA up to $200 a day is not tax deductible. Okay? So when, by way of further example, when an employee elects to run their bank of paid time off first before they take paid sick leave, and they can do that, you can't require it as the employer, but when they do that as the employee, you give them their paid time off, but you're not getting a tax credit for it, okay? Let's see, other questions. I'm looking for questions that I don't have to expand. Neil asks, does a stay-at-home order fulfill reason number 1 for ESPL or EP, the employee paid sick leave? And yeah, it checks a box, but it doesn't automatically mean that someone is entitled to paid sick leave just because there's a stay-at-home order. We talked about this earlier, so you can go back and watch the video. But it is one of the triggers, right? That is a quarantine order, but just because there's a quarantine order in place doesn't mean that the employee necessarily gets the paid sick leave. They still, if they're able to telework, for example, then they don't get the paid sick leave. That person, real short questions, folks. Then I can answer. If someone from a skeleton crew of an open business decides the stay-at-home applies to them, do they get PSL? If someone from a skeleton crew of an open business decides that the stay-at-home applies to them, do they get? I don't know how someone would unilaterally say that it applies to them. I mean, you still can request documentation to support that, and if someone provides a stay-at-home order and it doesn't apply to them, you can try and disavow them of that if they're incorrect. But if they are correct and they have to stay at home and your business remains open and there's otherwise work for them to do, then yeah, that's when they get the paid sick leave. I keep hearing about a $600 per week benefit for termed employees. What are you missing? You're not missing anything. That is under the Federal CARES Act. So I don't do a ton of CARES Act work. A lot of my partners do CARES Act work. So I usually turn those questions over to them, especially when my clients are asking for the PPP loans. I have many partners who are able to assist them. But I do know just enough that if I lose my job and it's due to something related to coronavirus, I'm going to apply for unemployment. I'm going to get state unemployment, and then I'm going to get an additional $600 per month. If I was working full time, I'm going to get an additional $600. Not per month, I'm sorry, per week from the federal government for 4 months. So you're going to have employees who are making over $1,000 a week on unemployment between state and federal. Someone says there is a limit of 80 hours period. Oh, that's an answer to someone else's question. Yeah, there is a limit of 80 hours period for paid sick leave. That is absolutely true. PPP for church staff? I don't see why not. If you've got less than 500 employees, yep, I think so. Again, I'm not the PPP expert, but I do know that it's for small businesses up to 500 employees, and I don't think there's any sort of exemption or exception for churches. Let's see. Here's a question. Oh, hey, John, how you doing? Do we have to accommodate staff who can't work from home due to no help with childcare when they are otherwise able? Do we have to accommodate staff who can't work from home due to no help with childcare when they're? Oh, yeah. I mean, that's it. Oh, do we have to accommodate them? I mean, that's when you give them the PSL and you give them the EFMLA. Sure. Yeah. If they have to, if they can't otherwise if they could otherwise telework but can't because they are caring for their children who are home, they just don't have the bandwidth to do both, and they choose to care for their kids, then you would provide them with the paid sick leave and then the EFMLA, assuming they've worked for 30 days. Question for Mike and Kim, and then I think I'm gonna cut this one off. Last question. Mike and Kim ask, do we pay both spouse employees EPSL or EFMLA for reason number 5 at the same time? So reason number 5 is the EFMLA reason. That is the stay at home to care for a child who can't go to school because the school is closed due to coronavirus or there's no child care available. Do you pay both spouses? And the answer is no, because it's a 1-to-1 ratio, right? 1 or more kids per spouse. So if I were in my situation, I'm at home, I have 4 kids, my wife is at home. If we decided to tag team it, and my wife took care of 2 kids during the day, I took care of 2 kids during the day, neither of us could work, we worked for the same company, yeah, I think you'd have to pay us both the EPSL and the EFMLA, okay? Let's flip it a little bit. My wife, who's a school teacher, God bless her, so she's dealing with a virtual class, and she's taking care of the 4 kids. if we worked for the same company, if I worked for the same school as my wife, and I'm able to do my work during the day without having to care for any kids, then no, you wouldn't provide us both with the PSL or the EFMLA. If two parents caring for one child, no, you don't pay both. It's just one of them. I think I see more questions coming in, but I think I'm gonna cut it. Yeah, 'cause unfortunately, I see emails coming in. Colleagues are calling me because clients have, no offense, folks, have paying Families First Coronavirus Response Act questions that I have to answer. Otherwise, they may not be clients for that much longer. So I do have to cut out. Thank you very much for attending today. We will do this again. We will do this on the regular, not every day, but we'll try and aim for this once a week. I will continue doing vlogs on the blog, if that makes sense. You guys seem to like those. I'll mix in some regular blog posts too. I'll try and do some Zoom chats with partners, and I'll post those. I'll try and keep you as informed as I can. Above all, whether it's me or anyone else, if you have questions, talk to a lawyer and get answers, get help. Again, none of what I talked about today was legal advice though, right? I do that with clients. I'm not asking any of you to become clients. I'm just saying, if you need help, do get in touch with a lawyer. If you want to learn more about me, you can check out my blog, theemployerhandbook.com. You can also check out my bio on my law firm's website. That's Fisher Broyles, BROYLES, FISHER, BROYLES.com. What else can I tell you? I think that's pretty much it. I'm going to post this video, part 1 and part 2. Sorry about the technical difficulties. And thanks everyone for attending. What's the standard? The standard way to say goodbye now is stay well, everyone. Stay well, stay safe, and have a great weekend. Bye.